Hello everyone, welcome to Mentora IAS. I am Safir and I welcome you all to this session on Current SAAR. So Current SAAR is basically a 16-month long free current affairs coverage course brought to you by Mentora IAS. So in today's session we are going to discuss few concepts from Indian polity from the month of February 2025. Okay. So today what we are going to see are three very important topics which also have frequency of questions being asked in the prelims examination. So today first of all we are going to discuss about Panchayati Raj system, then we'll be moving on to President's Rule, and the third one would be a statutory body that you know as the National Human Rights Commission. So let us begin with this particular session, but before we go ahead I would like to draw your attention towards the social media handles of Mentora IAS. I would really want you to join these particular channels in whatever platform you are at. You might be at Instagram, Facebook, YouTube or Telegram. So I request you all to join these particular channels because this is where you will be getting a lot of UPSC centric content, and at the same time you will also be receiving a lot of quizzes, information and motivation related to UPSC. Especially, I would like to draw your attention towards the Mentora IAS Telegram group. Please join this particular channel because here we are going to provide detailed handouts of every single current affairs lecture that is there on this particular channel. Okay, there is no current affairs lecture in this channel without any kind of handout. So with this, handouts are very detailed and at the same time they have been there in order to reduce your burden of making notes. Okay, we would want you to only augment that part which you do not know. Apart from that, there is absolutely no need for taking the burden of making the notes. You just listen to our classes very carefully, understand things, ask your doubts and revise and consolidate your learning from the handouts. So if you have not yet liked and subscribed our channel, please do that, and subsequently also share it with other co-aspirants so that you can share the benefit of current affairs. Okay, because this is something which is a mundane and Herculean task and we are here to solve it for you. So let us begin with the first concept that we have at hand, and that is the status of devolution to panchayats in states. So this is basically a report that has been recently released, and this basically tracks the amount of devolution that has been done by the state legislatures and the state government towards the panchayat. Okay, so this has been in news because recently by the Ministry of Panchayati Raj, this particular report has been released, and that title of the report is Status of Devolution to Panchayats in State. Okay, so this particular report has been prepared by Indian Institute of Public Administration, IIPA. This was also the institution which for the very first time brought up this particular devolution index, but subsequently after a hiatus of 7 years this was resumed by IIPA. Okay, now this particular report actually has the objective to evaluate how far have the panchayats been given the powers from the state legislature or from the states so that they could be functioning and fulfilling the role that was actually given to them or imagined out of them from the 73rd Constitutional Amendment Act 1992. Okay, so when we talk about this entire structure, what exactly has been the structure of the devolution index? So we first have to understand what exactly have been the objectives. So the first objective is to evaluate the progress, okay, which is basically about actual decentralization that needs to be done. So one of the aspects of 73rd Constitutional Amendment Act is that there are certain provisions which are mandatory, which are to be implemented by the states, and there are certain which are discretionary or something which are voluntary to be implemented by the states. But the point is that as long as the states do not devolve or do not give sufficient amount of powers to the panchayats from these particular list, the panchayats will never be self-sustaining and autonomous in functioning. So that is what is the first objective, to understand how far the devolution has been reached with respect to functions, institutions, functionaries and finances to the Panchayati Raj institution. Okay, the second one is basically what exactly has been the role of panchayats in furthering the goal of local self-government. And third, it is basically how the panchayats can be used as the machinery to implement centrally sponsored schemes and central sector schemes. Okay, so these were the three objectives of this particular report. Now the report has been based upon 6 dimensions, and these dimensions are the framework, function, finances, functionaries, capacity building and accountability. Okay, so framework basically talks about the way in which the elections are held, how frequently are they held, and subsequently what is the fairness in these elections. Functioning is about devolution of powers from the 11th schedule. Finances about how far the finances are allocated from the state so that panchayats have sufficient amount of money and resources to initiate and at the same time execute welfare schemes and welfare based functions. Okay, then functionaries is about how many officials have been actually allocated and how far the bureaucracy supports this particular framework. Then capacity building, that basically is about how the personnel at the level of Panchayati Raj have been trained and how exactly are they executing their functions. And finally, accountability. So when this particular index was made, it was found out that the highest ranking or the top ranking states have been Karnataka, Kerala and Tamil Nadu, the three which were the top. Okay, and it was also found out that the devolution has increased from 39.9% to 43.9% in a 10-year span. Okay, now this particular report does not include states of Meghalaya, Mizoram and Nagaland. Okay, because this particular states have actually been exempted under the part 9 of the Constitution of India, that is the 73rd Constitutional Amendment Act. The provisions of that particular act do not apply to these states. That's the first thing. Okay, second, that they have been, this does not include any panchayats, or for that matter let's not go with panchayat, but rather let us talk about Union Territory of Chandigarh. Because in the Union Territory of Chandigarh, it has been found that there are no panchayats. Okay. Then the third one, which is not included here, is actually the National Capital Territory of Delhi. Okay, where the panchayats were superseded in 1990, and since then they have not been revived. So these are the regions which are not included in this particular report for various reasons. Okay, apart from that, all these states and union territories have been accorded space and they have been studied in this particular regard. Now, that is all about the report. Now let us understand the Panchayati Raj system in accordance to the 73rd Constitutional Amendment Act 1992. Okay, so that was the 73rd Constitutional Amendment Act of 1992. Okay, so when we talk about Panchayati Raj in that particular manner, so we see that Panchayati Raj was initially not a constitutional body. Okay, so when the constitution began, when we gained independence from the British and subsequently our constitution was framed, so Panchayati Raj was basically a part of Article 40 of the Directive Principles of State Policy. Okay, so this was basically given to the central government that when it has got sufficient resources, it will be an endeavor of the central government to organize panchayats at the level of villages. Okay, so initially this was the case, although Panchayati Raj was the ideal form of government that was actually imagined by Gandhi for India, that it will basically be a union of a lot of village republics operating autonomously together. Okay, but this was given a space only in Article 40 at the very beginning. Okay, that's the first thing that we need to understand. Now Panchayati Raj was accorded constitutional status. Okay, this was accorded constitutional status in 73rd Constitutional Amendment Act 1992. So in 1992, finally it was made constitutionally mandatory for the states to have this third tier of the government coming up. So when you talk about the original Constitution of India that existed in 1950, there were only two tiers of government given. One was the central or the union government and the second one was the state governments. Okay. The third type of government was not envisioned in the original constitution. It actually came up, the third tier came up in 1992 via the 73rd Constitutional Amendment Act. Okay. Now what exactly does this include? So when you talk about the 73rd Constitutional Amendment Act, it actually introduced part 9 to the constitution. Okay. Part 9. So this part 9 is basically what is called as, or what has been titled as, the Panchayats. Okay. The second thing that has been introduced is basically the articles which have been modified are actually articles 243 to 243O. And the third thing that has been included is basically the 11th schedule. Okay. So the 11th schedule basically is about devolution of powers. Devolution of powers between state and panchayats. So it basically has 29 such subjects. Okay, this has got 29 subjects. The next thing that we understand with respect to the 73rd Constitutional Amendment Act is that it gives a complete structure of how exactly the constitution of Panchayati Raj is going to happen in the country. So let us now understand the features. Okay, so let us talk about the broad features of 73rd Constitutional Amendment Act 1992. Okay, so the first thing it talks about is basically Gram Sabha. Okay, so Gram Sabha basically has been listed down under Article 243A. Okay, so Gram Sabha is the only permanent body of the Panchayati Raj system. Okay, so when we talk about the Gram Sabha, so Gram Sabha is something which is having all members above the age of 18 years registered in the electoral roll. For the panchayat. So for this particular panchayat, whoever has been registered in the electoral roll and is above 18 years of age is actually a member of the Gram Sabha, and that is why this is the only permanent unit of the Panchayati Raj. Okay, it cannot be dissolved. Please remember this particular part. Okay, the next thing that we need to understand with respect to Gram Sabha is that the powers of the Gram Sabha. Okay, powers of Gram Sabha are determined or are given by state legislature. So whatever the state legislature is going to give as power, that is the only function of Gram Sabha. Okay, so this is all about the Gram Sabha. When we talk about the composition of panchayat, okay, the next thing that we have is basically the composition of panchayat. So when we talk about the composition of panchayat, this is Article 243B. So composition of panchayat is Article 243B, where we talk about a 3-tier government. Okay, so a 3-tier you can say composition has been envisaged. One at the level of village, second intermediate level, third one is district level. Okay, so with respect to this, when we talk about the intermediate level, this is something which is actually optional this is optional for all those states where population is less than 20 lakhs. Okay, where population is less than 20 lakhs, the intermediate level is optional. Apart from that, village and district level have to be there. Okay, now the next thing is, because we have panchayats, so it has basically been said that all levels of panchayats, okay, that basically encompasses the village, intermediate and district levels, shall have their members directly elected by the people. Okay, so direct election is something which is present here, elected by people who are going to be members of the Gram Sabha and subsequently the electoral roll. So they are all directly elected. Okay, apart from that, there is also provision for reservation. Okay, so there is reservation as well. Okay, now reservation is also twofold. Okay, one is for scheduled castes and scheduled tribes in accordance or in proportion to their population. Okay, that is the one which has been given. The second thing that has been given is that 1/3 of the seats, 1/3 of all the seats rather. Okay, now these seats are basically going to be the reserved seats, plus the general seats. Both the seats are basically the ones which shall be reserved for women. Okay, so this was basically the first kind of tier of the government where this particular reservation had been accorded. Okay, apart from that, with respect to this particular reservation, it was also the case that with respect to this reservation, it has also been said that constituencies to be reserved may be allocated on rotational basis. Okay, that's the next thing that was said to it. Okay, now when you talk about these two provisions, okay, this provision and this provision, very sorry, this would be women. Okay, I will just correct it, women. Okay, so this provision, 1/3 reservation for women, and the constituencies that will be reserved for this particular purpose will be allocated on a rotational basis. So they are not going to be fixed, but they will be rotated across the entire panchayat. Okay, so what basically has been that there is that these two provisions have also found their way into the 106th Constitutional Amendment Act, that is called the Nari Shakti Bandhan, that seeks to provide 1/3 reservation to women in Lok Sabha and state legislative assemblies. Okay, so this has also been a 2023 previous year question on 106th Constitutional Amendment Act, that is the Nari Bandhan Shakti Act. Okay, so in that particular you can say act, this is also a feature that has been taken from the 73rd Constitutional Amendment Act. Okay, so remember this. Apart from reservation, it basically also talks about tenure. Okay, it talks about tenure. So when we talk about tenure, there is a normal tenure of 5 years. Okay, but at the same time there is also a provision for premature dissolution. Okay, premature dissolution by state government. So there are also provisions for this particular thing. Okay, So when you talk about the normal tenure, so it is also seen with respect to the normal tenure, it is seen that this is not to be disturbed. Okay, this is not to be disturbed, and fresh elections should be conducted 6 months before the expiry of current term. Okay, so 6 months before the expiry of current term, this particular elections have to be conducted. Okay, with respect to the premature dissolution, okay, a re-elected panchayat, will only serve the leftover tenure of the dissolved panchayat. So whatever was the amount of time that the dissolved panchayat actually was existing, so we will be reducing that particular time. So any panchayat that will be re-elected after dissolution or premature dissolution, they will only serve a limited time, not a complete 5-year term. Okay, so these are basically the various, if I have to tell you, the various provisions which are related to the entire 73rd Constitutional Amendment Act. Apart from this, there are two other provisions as well, because first of all we are talking about having direct elections. So that is why in order for that direct elections to take place, we have to have two more things. Okay, first we need to have a state election commission, because when we talk about the Election Commission of India, that is basically responsible for conducting the elections to the office of president, office of vice president, then the elections to the parliament, both Lok Sabha as well as Rajya Sabha, and the election to the state legislative assemblies. That is within the purview of the Election Commission of India. And State Election Commission basically is appointed by the governor, and this is basically responsible for overall supervision, conduct, direction of the Panchayati Raj elections. Okay, apart from that, they are also responsible for preparation of electoral rolls. Okay, so preparation of electoral rolls is done separately for Panchayati Raj elections. Okay, when you talk about the electoral rolls with respect to the General Assembly elections, that is the Legislative Assembly election and the Lok Sabha, the electoral roll basically is used in the same manner. Okay, there is no separate electoral rolls for them, but with respect to Panchayat, there are separate electoral rolls. Okay, so this is the first institution that has been there with respect to the Panchayati Raj system. The second one is basically the State Finance Commission. Okay, there is a State Finance Commission. Now this particular commission is also appointed by the governor. Okay, appointed by the governor, usually after every 5 years. Okay, so we need to remember this, that usually after every 5 years we have this particular thing coming up. Okay, apart from that, when we talk about the State Finance Commission, this basically evaluates the financial position. Okay, it evaluates the financial position of the Panchayati Raj or Panchayats. Okay, So then subsequently it also recommends what exactly should be the amount of grants in aid that has to be transferred, what exactly has been the amount of revenue that the state governments need to share with the panchayats, what sort of tolls, taxes and duties and fees that should be given to the panchayats for their self-sustenance. Okay, so this is all that is there with respect to the 73rd Constitutional Amendment Act. Now, one of the major limitations of the Panchayati Raj system in India as of now has been that there is a significant reliance over the grants that are actually given by the state government. Okay, so major source of financing of the Panchayati Raj is actually the grants, and that is why most of the time we see that the Panchayati Raj is cash strapped. Why? Because it does not have significant source of revenue from other things, although the state government may authorize them to levy certain local taxes, but still they do not form a significant corpus of money for the panchayats to spend upon. So that is why it is very important that we actually go for such institutions or such level of devolution that the Panchayati Raj becomes a self-sustaining source of finance, and subsequently then this financing could be used for the grassroots level of delivery of services. Okay, so that is basically what we have with respect to the Panchayati Raj. Now let us talk about this particular question. Okay, yes, one more thing that we need to understand here is that the minimum age for any individual person to actually fight or contest a Panchayati Raj election is 21 years. Okay, remember this. For fighting the elections to the Legislative Assembly, you should be at least 25 years old, but for Panchayati Raj elections, you should be at least 21 years old. Okay, now let us go towards this particular question. Consider the following statements. Part 9 of the Constitution, inserted by the 74th Constitutional Amendment Act 1992, added a chapter on Panchayati Raj to the Constitution. Okay, then the Panchayati Raj was separately established in the scheduled areas through another constitutional amendment. Which of the above statements is or are correct? So the first statement, part 9 of the Constitution, is inserted by the 74th. Okay, so we have to be very careful about the amendment. 74th Constitutional Amendment Act 1992 added a chapter on Panchayati Raj to the Constitution. Wrong. It is 73rd, not 74th. Okay. The second one, Panchayati Raj was separately established in the scheduled areas through another constitutional amendment. This is also wrong. For the scheduled areas, there has been a simple act that basically goes with the name of Panchayati Raj Extension to Scheduled Areas. Extension to Scheduled Areas Act. Okay, 1996. It is in short also called as the PESA or PESA 1996. Okay, so it was not a constitutional amendment, that was a statutory step. So which of the above statements are correct? So the correct answer would be option D, neither one nor two. So this also brings us to another observation. Okay, that part 9 does not apply to scheduled areas. Okay, scheduled areas, when you talk about the scheduled areas, these are basically the scheduled 6 areas. Okay, of Assam, Mizoram, Meghalaya and Tripura. Okay, so for them we actually have got the PESA Act. For them we have enacted separately the PESA Act of 1996. Okay, the second thing that has been there is that it does not apply to states of Mizoram, Meghalaya and Nagaland as well. Okay, because of their predominantly tribal nature, it does not apply completely to Mizoram, Meghalaya and Nagaland. Third, hill regions of Manipur, and district provisions do not apply to Darjeeling district. Okay. So Darjeeling district of West Bengal in the hilly region, that also does not have this particular thing applicable. Okay. So the part 9 of the constitution does not apply here. So that is why you have just seen that with respect to the devolution, state of devolution also, this particular region was exempted. Okay. Now, this is UPSC 2016's question. So the question is, consider the following statements. The minimum age prescribed for any person to be a member of Panchayat is 25 years. A Panchayat reconstituted after premature dissolution continues only for the remainder period. Which of the statements given above is or are correct? So the first statement, the minimum age prescribed for any person to be a member of Panchayat is 25 years. This is wrong. Okay, this is completely wrong. It is not the case. A Panchayat reconstituted after premature dissolution continues only for the remainder period. This is correct. This is a correct statement. So this basically comes from article 243E, which talks about the tenure of the Panchayat. Okay. So now the correct answer here would be option B. Okay, 2 only. That's the correct answer. Now UPSC 2014, another question. The fundamental object of Panchayati Raj is to ensure which of the following? People's participation in development, political accountability, democratic decentralization, financial mobilization. Okay. So we basically have to tell what exactly have been the objectives of the Panchayati Raj institution. So even if we do not understand anything, we know that option 3 will definitely be correct, that there will be democratic decentralization. Then at the same time, option 1 will also be correct, because this is the only level at which people directly participate in decision making. Okay. So 1 and 3 are correct. Now political accountability and financial mobilization. Now these were not the original objectives of the Panchayati Raj. Panchayati Raj wanted people to become the rulers of that particular place, or make people feel more responsible towards the administration or decision making of a particular place. So the correct answer of this would be option C, 1 and 3. Okay. So this is the correct answer here. Now let us move on to our next topic, that will be President's Rule. And why exactly are we discussing President's Rule? Because President's Rule was imposed over Manipur after the resignation of the Chief Minister, of the incumbent Chief Minister N. Biren Singh. Okay. Now after N. Biren Singh resigned from his position, no other party, or for that matter no other candidate, could be selected amongst the elected representatives to head this particular state, and subsequently President's Rule has been imposed. Further, in the month of August, this particular President's Rule has been extended till February 2026. So in February 2026, this entire President's Rule is going to complete 1 year of imposition in Manipur. So Manipur basically has been torn by the ethnic conflicts that have been going on between the Meitei and the Kuki-Zo community. Okay. So till now there has been you can say a sense of you can say unrest that has been prevailing. There have been skirmishes and there have been confrontations on both the sides, and that is why President's Rule as of now has been applied here. So when we talk about President's Rule, so President's Rule, if we have to talk about it, that actually is imposed under Article 356. Okay. So Article 356 of the Constitution. So when you talk about it, so Article 356, first of all we have to understand, it does not contain the term President's Rule, okay, or state emergency. Both of them are not given officially in the Constitution of India. These are actually colloquial terms, the terms which are used by ordinary you can say representation, for that matter for the journalistic purposes. Both of them do not have any kind of mention in the Constitution of India. That's the first thing that we have to understand with respect to Article 356. So Article 356 basically is a part of emergency provisions. Okay. So when you talk about the emergency provisions, they are provided by Part 18. Okay, so emergency provisions are given under Part 18 of the Constitution of India. Okay, so when we talk about this particular article, Article 356, so it basically is about the failure of constitutional machinery. Okay, failure of constitutional machinery in states. Okay, so this is basically the exact point that actually is the trigger of Article 356 invocation. Okay, so when this particular situation arises in the state, so based upon the report of the governor, okay, so this is something which is to be reported by the governor, that in the state the situations are such that the government cannot be carried out with respect to the existing provisions of the constitution. So at that particular time what happens is that the Article 356 is invoked by the president. So there basically comes up a proclamation. Okay, so it is basically a proclamation. And what exactly is the proclamation all about? It is basically about two things. Okay, so when we talk about the proclamation, so this proclamation will have a few aspects. Okay, the first aspect is that president assumes functions of the state government. Okay, functions of state government, and at the same time the second thing is any power vested in the governor. So that is something which has to be done. Okay, this is there in the proclamation. The president is first of all going to assume this power. So what exactly is this power? This is the executive power of the state. That is something which is assumed by the president. Now at the same time there could be a second one, that the legislature of the state, will be assumed by the parliament. Okay, now that's the second thing, that the legislative functions will now be assumed by the parliament. It will not be done by the state legislature. So this also tells us that with the proclamation getting issued, okay, the legislature is suspended, or legislature of state is dissolved. Okay, with the first one what we see, when the president is assuming this power, the government is also dissolved. Okay, government is dissolved. Okay, now the third thing, president cannot assume the powers of the High Court. That's the only thing that remains with the state. Okay, so only the High Court of the state is the one which is going to function within its own jurisdiction. Its powers will not be superseded by the president. Okay, with respect to the execution or the executive wing, that is something which will be done by the president. The government is going to be taken over. Any power which is vested in the governor is going to be taken over by the president. Okay, the legislature is going to be handled by the union legislature, that is the parliament. And that is why, according to this particular thing, if a particular state actually has been under the president's rule for some time, their budget is also considered and passed by the parliament. Okay, this is exactly what has happened with Manipur in February 2025, that its legislature was considered and passed by the Parliament of India. Okay, so remember this, these are small details that we actually miss. Okay, then the president does not assume the power of the High Court. Now that's the thing. Okay, Now, as far as this particular proclamation is concerned, okay, so when the proclamation is issued, okay, when the proclamation is issued, now there are certain things that we have to understand. Okay, it can be revoked by issuing another proclamation that this is going to be cancelled. Okay, so that is something which could be done by the president. The second thing that happens is that this particular proclamation, has to be approved, by both of the houses of the parliament. Okay, has to be approved by both houses of the parliament within 2 months. Okay, within 2 months from the date of issue. The next thing that we need to understand with respect to this is that this proclamation, okay, this is going to be in force for 6 months after receiving approval. Okay, then at the same time, this is something which can be renewed after 6 months with the approval of the parliament. Okay, and subsequently this can be done for a maximum of 3 years. Not beyond that. Okay, now that's the thing. Proclamation is issued in such a manner and these are the limitations to it. Okay, now there are also limitations with respect to the issuing of the proclamation beyond 1 year. For the continuation of that particular proclamation, there are 2 limitations that have been put up. Okay, so what exactly have been the limitations? To extending the proclamation. So these 2 limitations are, okay, the first one is basically if there is a proclamation of emergency, that basically means national emergency. That is what we know as the national emergency. So if there has been the national emergency which is in force, okay, in the country or in the state, because when we talk about the national emergency, that is something which could be applied either to the entire country or to a part of it. Okay, so in that particular case, the proclamation can be extended, okay, or in the state. So if you want to extend it beyond 1 year without hiccups, you will have to declare emergency, and that will be a national emergency which is declared on the grounds of external aggression or for that matter armed rebellion. Okay, so these are the 2 units. Then the second thing, if this is not the case, if the election commission, okay, if the election commission of India certifies its inabilities to conduct the election, so at that particular time what is going to happen, this is something which will be continued. So these are the 2 limitations that are there with respect to extension of the proclamation beyond 1 year time. Okay, so this is basically the scenario that we have. Now when we talk about judicial review, okay, so judicial review is something which is allowed. So when we talk about the judicial review, it is allowed. and this was actually given in under the SR Bommai case. Okay, so in the SR Bommai case, the Supreme Court said that proclamation of the President's rule or the state emergency as it is called, it is open for judicial review. Okay, and what exactly is it open for? What are the grounds? These grounds are actually malified intent, hasty decision, abuse of power, fraud. These are basically the things that can actually be the grounds for the judicial review to take place. Okay, so this was something which was given under the SR Bommai case. So this is basically how we see the President's rule and its operation coming up. Okay, so now let us talk about the question. So consider the following statements. The Constitution of India terms the President rule as state emergency under Article 356. The second statement is the exercise of Article 356 allows for the transfer of legislative, executive and judicial powers to the center. Okay, the budget of such a state is passed by the Parliament of India. Which of the above statements is or are correct? So we know from our discussion right now that the Constitution of India terms the President rule as state emergency under Article 356. This is wrong. The Constitution of India neither mentions President's rule nor it mentions state emergency for Article 356. It is wrong. Why exactly has it been named about the President's rule? Because of the proclamation. The first feature of the proclamation is that the President is going to assume the powers of the government. That is why it has been informally called the President's rule. The second one, the exercise of Article 356 allows for the transfer of legislative, executive and judicial powers to the center. Wrong. Judicial powers are never transferred. It is only the legislative and executive powers that are going to be transferred. The third one, the budget of such a state is passed by the Parliament of India. This is correct. So the correct answer here would be option D, 3 only. Okay, so that was the question. Now the second question is, consider the following statements. Article 356 of the Constitution allows for the President to assume functions of the state government and powers vested in the governor to himself or herself in case of failure of constitutional machinery. And second statement that is given is Article 356 expressly defines the situations involving failure of the constitutional machinery. Which of the statements is correct? Both statements 1 and 2 are correct, and statement 2 is the correct explanation of statement 1. Okay, both statements 1 and 2 are correct, but statement 2 does not correctly explain the statement 1. Third one is statement 1 is correct and statement 2 is incorrect, and the fourth one is statement 1 is incorrect while statement 2 is correct. So we have to first of all evaluate the factual correctness of these two. After evaluating the factual correctness, then we have to answer based upon this. So Article 356 of the Constitution of India allows for the President to assume powers of the state government and powers vested in the governor to himself or herself in case of failure of the constitutional machinery. Correct. This part is correct. Okay, statement 1 is correct. Article 356 expressly defines the situations involving the failure of constitutional machinery. This is incorrect. There has been no definition of this, that what exactly is going to be covered under the failure of constitutional machinery. That is why a detailed report from the governor is required before this proclamation is issued. Okay, so this is wrong. So we have to find out the option which says that statement 1 is correct and 2 is incorrect. That is option C. Okay, so this is basically the second statement that is there. So I hope this is something which is clear with you, what exactly has been the President's rule and what are the various constitutional provisions with respect to the President's rule. Now let us move on to the next topic, and that is basically on the National Human Rights Commission. So National Human Rights Commission saw two appointments happening. Okay, with respect to the month of February 2025, we see that there were two appointments that actually happened from the government side. Okay, so both of these appointments are actually judicial members who were appointed to the body. So when we talk about it, it is basically the President of India appointed two members. One, the chairperson of NHRC, who is Justice V. Subramaniam, former retired Supreme Court judge, okay, who is now the chairperson, and then Justice Dr. Vidyut Ranjan Sarangi, who basically was the former Chief Justice of Jharkhand High Court, as a member. And then the third member who was appointed was Priyank Kanungo, former chairperson of National Commission for Protection of Child Rights, okay, as member. So 2 members and 1 chairperson. So this is the chairperson, okay, so this is Justice V. Subramaniam, okay. Then when you talk about the next one, so this is Priyank Kanungo, okay. So the orange blazer is basically Priyank Kanungo. And then this is, here we have Justice, this one is Justice Vidyut Sarangi, okay. So these are the 3 members who have been appointed to the National Human Rights Commission, and now the composition of this particular commission is the following, okay. So we have Justice Subramaniam, this is the chairperson, okay, chairperson. Then this is Vijaya Sahani, she was the acting chairperson, okay, she was the acting chairperson before the appointment of Justice V. Subramaniam, and these are the members, okay, these 2 are the members. And when you talk about this particular gentleman, he is actually the Chief Executive Officer and Secretary to the NHRC, Bharat Lal, okay. So these are the individuals who have been the composition of the NHRC, okay. So when we talk about the National Human Rights Commission, so National Human Rights Commission is basically based upon the Protection of Human Rights Act, okay. This is a statutory body, Protection of Human Rights Act 1993. This has been a statutory body because it has been established under the provisions of this particular act, okay. So this basically means that NHRC is a statutory body, okay. So this particular body has been in compliance, or you can say India's commitment to the Paris Principles, okay. So Paris Principles were basically a set of guidelines that were actually accepted on the very first conference of the National Commissions of Protection of Human Rights around the world, okay. So this was basically the one which was endorsed by the United Nations General Assembly, and based upon that India's commitment was to enact this particular legislation and then subsequently have a dedicated body called the National Commission for Human Rights, or NHRC. So when we talk about this particular act, so this act also defines human rights, okay. It defines human rights which are covered in the country, okay. So when we talk about the National Human Rights Commission, the primary objective of this particular commission is to investigate into the matters where human rights are either violated or their violation has been done by a public servant, okay. So in general, if there has been any violation of the human rights, that is basically the first kind of complaint that it receives, and the second one is that if there has been any negligence on the part of public servants, okay, with respect to adhering and respecting the human rights, now that is something which will be dealt with by the NHRC, okay. So when we talk about human rights, now these are a set of rights that actually belong to every single human by the virtue of being a human, okay. So regardless of any kind of nationality, any kind of you can say economic, social, political background, any kind of you can say religion, so what basically happens is that this is something which is available to every single individual, okay. Now this is basically based upon a declaration of human rights that was given after the you can say constitution of the United Nations organization, that is called the Universal Declaration of Human Rights, okay. Now from that, many of the rights have actually inspired the fundamental rights in India, and subsequently other rights which are not there, okay, they are basically the ones which are covered under the human rights. Now when we talk about the human rights, so this is inalienable, okay. So when you talk about in human rights, they are inalienable, meaning that regardless of any individual belonging to any place, any nationality, anything, but just by the virtue of being human, this is something which is gifted by the nature or by the God to the humans. So no one can take this away and no one at the same time can bestow it. Okay, so that is why human rights are a very wide ranging set of rights. So when we talk about the NHRC, so when we talk about the composition, so this particular act talks about the composition. Okay, composition of National Human Rights Commission has been given in the following manner. Okay, there would be a chairperson, there has to be a chairperson. Okay, now this particular individual would be either former Chief Justice of India or a former judge of Supreme Court. Okay, that particular individual will become the chairperson of this particular commission. Now the second one would basically be the now we talk about members. Okay, so when we talk about members, now these members would basically be the one where you would be having a retired Chief Justice or judge of a high court. Okay, that has to be another member here. Then at the same time there has to be 3 members. Okay, 3 members with specialized knowledge and experience in the field of human rights. Okay, that is the next thing that is basically present here. So out of these 3 members, at least one has to be a woman. Okay, now all of these individuals who basically form the NHRC, now these are basically the individuals who are all appointed by the President of India. Okay, appointed by President of India on the recommendation of a particular committee. Okay, so we'll be discussing that committee as well, but all of them are appointed by the President of India. That is something that we need to know very properly. Okay, apart from that, there are certain deemed members as well. Okay, there are certain deemed members. Now deemed members are basically the one which have been ex officio members of this particular organization because they are the heads of some other child protection bodies. Okay, so these deemed members are actually chairpersons. They are actually chairpersons of National Commission for Scheduled Caste, National Commission for Scheduled Tribe, National Commission for Backward Castes. Okay, then National Commission for Minorities, National Commission for Women, and National Commission for Protection of Child Rights. Now the individuals who basically head these particular organizations, they are actually deemed members of this particular organization. Apart from that, we have seen that there are members who are actually there. Okay, now when we talk about the search and selection committee for the chairperson. Okay, search and selection committee. So this basically is the one which has some ex officio members. Okay, so there is basically the Prime Minister of India. Okay, the second one is Union Home Minister. Okay, then the third one is Speaker of Lok Sabha. Then we have Leader of Opposition. Leader of Opposition, Lok Sabha. Leader of Opposition, Rajya Sabha. Then the next one is basically the Deputy Chairperson of Rajya Sabha. These are basically the 6 individuals who basically form the search cum recommendation committee of this particular organization. So they are the ones who are going to consider and vet the names who basically have been proposed for the post of chairperson and other members. Okay, and based upon their recommendation, the appointments will be subsequently made by the President of India. Okay, so when we talk about the tenure, okay, so when we talk about the tenure, so tenure is basically 3 years for all. Okay, that basically means chairperson and the other members. Okay, that is the first one. And the second one, okay, there is an age ceiling. Max age can be 70 years. So either of them, either you have finished a 3 years tenure, or for that matter you have attained 70 years of age, then subsequently you retire. Okay, so these are the two limitations. Now at the same time, the third one is that after finishing of the tenure, there can be no subsequent appointment of the chairperson or the members to any other position of union or state governments. So after this particular appointment as the members of the National Human Rights Commission, so at that particular time you cannot be reappointed to any other position, let alone be the members of this particular commission. Okay, so that is why once you have attained this particular 3 years time period, you have served there, now you are ineligible for any further appointment. Okay, so within this 3 years a member can be appointed as chairperson, that's a different thing. Okay, within these 3 years that could be done, but after your tenure you will not be eligible for this. Okay, so this is basically the tenure. Now at the same time, when you talk about removal, okay, so when we talk about the removal of you can say members, so first kind of removal is basically based upon resignation. Okay, so the individuals can resign from this particular position, and in that particular scenario what is going to happen, there will be a casual vacancy. Okay, there will be a casual vacancy either due to resignation or basically due to death. Okay, that will be casual you can say vacancy. Then the second one is basically removal on the recommendation of Supreme Court or on the reference of Supreme Court based upon a presidential reference. Okay, so that is something which will be required with respect to Article 143. So within Article 143, when the President is going to seek the advice of the Supreme Court on this particular regard, so the grounds will be incapacity or proved misbehavior. Okay, that is the second one. Apart from that, this can also be removed. The individuals can also be removed on the basis of the fact that they are undischarged insolvent. Okay, for that matter, they are mentally unstable or unfit for continuing in this particular job, and that is so which has been you can say designated by the Supreme Court. So these are the various ways in which you basically see the removal of these individuals happening. Okay, so upon this, what is going to happen in this particular regard, the President is going to be the removal authority of these individuals. Okay, so that is basically the concept of removal. Now finally, when we talk about it, so we have functions. Okay, so with respect to functions, the first one would always be investigate. Okay, but this investigation could either be taken up through a petition, that a petition has been filed. Okay, or this could be a suo motu initiative or suo motu action. That basically means that they could actually be initiating this investigation based upon their own observation. Okay, on cases related to violation of human rights. So I am writing HR for human rights or abatement of them. Okay. Then the second one is negligence. Negligence of implementing these rights by public servants. Okay. So either a complaint may be filed or they may take up this particular job on their own. Okay. In both the cases they are going to have this particular power. Apart from that, they can also intervene in the matters being tried in courts for the violation of human rights with the concurrence of the court. So if a particular matter is being tried in the particular court, so with the permission of the court, they can actually be intervening in such matters, or for that matter the courts may order an investigation by the National Human Rights Commission. Okay. Apart from that, it is also their responsibility to conduct research. Okay. And at the same time, it is also their responsibility to spread awareness about the human rights throughout the country. Okay. They will also be allowed to visit prisons. Okay, they will be allowed to visit prisons where the individuals are detained either for reformation, protection or juvenile. Okay, so in order to understand the conditions of such imprisonment or you can say confinements, and subsequently then recommend what exactly should be the remedial measures. So these are basically the broad functions of the NHRC. Okay, so NHRC basically has got all of these functions that are to be done. While it is investigating at that particular time, the NHRC will be having the powers of a civil court. Okay, so it can actually be summoning people and it can enforce attendance of some of the people in order to get some of the evidences, the statements. It can solicit, or you can say requisition, some of the records that it wants from the public offices. It can ensure that certain witnesses are going to come in for the deposition. So these are basically the things which the National Human Rights Commission is going to you can say have in its investigation, and after investigation it is going to recommend the suitable actions to the government. It is not something which is going to come up with any case of verdict. Okay, so it is not having any powers of giving a verdict or for that matter punishing any of the cases of violation of human rights. It can only recommend it to the government, and subsequently then the government is going to take the suitable action. Okay, so that is basically all we have with respect to the National Human Rights Commission. Now let us answer this particular question. Consider the following statements about National Human Rights Commission. It is a statutory body established under the provisions of Protection of Human Rights Act 1993. The NHRC is based upon the Rome Principles adopted at the International Workshop on National Institutions for Promoting Human Rights. Which of the above statements is or are correct? So I have just told you that National Human Rights Commission is basically the one which has been established based upon the Protection of Human Rights Act 1993. So it is a statutory body. Okay, because it has been established under the provisions of this particular act. The next one, NHRC, is based upon Rome Principles. This is wrong. It is Paris Principles. Okay, and the workshop which is mentioned is same, the International Workshop on National Institutions for Promoting the Human Rights. So the correct answer here would be option A, one only. Okay, that is the only one which is correct. Now the next one, consider the following statements about the National Human Rights Commission. The chairperson and the members of the commission are appointed by the President of India. Upon completion of the tenure, both the chairperson and the members may be reappointed subject to maximum age of 70 years. Which of the above statements is or are correct? So the first one, chairperson and the members of the commission are appointed by the President of India. This is true. This is correct. The second one, upon the completion of tenure, both chairperson and the members may be reappointed subject to maximum age of 70 years. This is wrong. They cannot be reappointed. Okay, so the correct answer here would be again option A, one only. Okay, so this is basically what has been the case of National Human Rights Commission. So I hope you were able to understand what exactly is human rights, and in this particular video it was a strong revision of your static part as well as how that static part is applied to the current affairs part. So if there is any kind of confusion, please let us know in the comment section, and if you like this particular video, please do like our effort, also share it with your friends, and subsequently we'll keep on bringing up much better content for you. Okay, so with that in mind, I really wish you best of luck, and please take very good care of yourself and study very properly, because the prelims is approaching very soon. Okay, so till then, thank you, all the very best.